Honorable Justice Chaudhary, Barrister Shailesh Mehta, Advocate Amardeep Singh, Assistant Advocate General of Haryana Government, Senior Advocate Adish Aggarwala, who is the President of International Jurists, Council of Jurists, all distinguished delegates, ladies and gentlemen and press. I've been asked to speak on the subject relation amongst the judiciary, legislation and executive. In fact, I'm not a designated speaker, neither am a practitioner lawyer or having experience like Mr. Aggarwala or the Justice Chaudhary was just spoke about here. But nevertheless, I have some questions as a representative of people, Republic of India, and also in a capacity as a editor of a newspaper. Last 40 years I have been editing the newspaper in India called Lokmat. It's in Marathi and it's a fourth largest newspaper in the country. Also publishing in Hindi, English, and also running a television channel called IBN Lokmat. And first of all, I must thank you, Shri Aggarwala ji, for bringing me here and giving me an opportunity to meet all of you and expressing my views on the subject. Let me tell you one thing first. Any system which works with the tradition and the culture. If you go and see the history of even 5,000 years old in the world, everything has been around the culture, the tradition, and the justice also came out of it. I feel proud that I come from a land of Mahavir, Buddha and Gandhi. And the preaching of Lord Mahavir, Buddha and Gandhi, which we got it, of equality, justice, live and let live. And I feel, keeping that spirit in mind, our judiciary, our constitution is working very well. There is no conflict between the judiciary, legislation or the executives. There are some occasions when there was some problems, one or two occasions between the executives and the judiciary, which was resolved. Though the executive is appointing authority for the judges, but I have not seen a single occasion where there was a dispute or any other issues crop up between the system. And that is the best thing which I see. But there are some questions which crop into my mind. And that is really, the justice has been given to the needed person. We see all over the world, the justice has become very, very expensive. And if you see the poor people, whom the justice has to be good, are being delivered to them, they are reaching there. If any person can go and get the justice, and I personally feel one has to be deliberate on this subject, how the poor can get the justice. There are many people we see, they are lying in jail for 10, 10, 15 years, 20 years, they could not release because they don't have the money or they don't have the power or they could not get justice. Just now, Honorable Justice Chaudhary has mentioned about Bangladesh and Bangladesh judiciary. Referring that issue, coming to my mind about Taslima Nasri, the writer, and the Muhammad Yunus, two persons. The Taslima Nasri could not get justice at that time. Maybe because there was no democracy or what it may be. And today she has been welcomed. But was there any system by which the judiciary would have been interfered and bring her back to the nation? Or the Muhammad Yunus, because of he don't have the age in his act, and he has to step down, and even the High Court said that he cannot continue just because he has been overage now. But can any other country could produce people like Yunus on that subject? That is came to my mind. Third thing, which always bothers me about the judiciary system, in which everybody has the right for the review. District court judgment, we go in the High Court and we review it. High Court judgments, we go in the Supreme Court and they go for the review. But what about the Supreme Court judgments? Who will review the decision which has been taken?
By Lord.
By the God. But I feel when everything we should not be given to God. What we can't do is just leave it to the God. I think God is seeing. But I feel there must be some system by which quarterly or 6 monthly there should be a panel of maybe retired judges, Supreme Court judges. They can review this the decision. Anyway, in a largest democratic country like India, we have been reviewing so many laws, the parliament, and ultimately, in the name of, like you see in the Muslim countries, they say everything is in the name of Allah. In democratic setup, we say everything in the name of the common man. The justice must reach to the common man. But really, the justice has been reaching to the poor man or common man, and to the last person of whom we've been taking the name as
concept to curb the particular activities, and the punishment is also severe. There are 7 years imprisonment, then the fine is there, plus ban is there. If some person has been caught by anti-corruption, if he's been caught on that issue, whether the case is decided or not decided, first he is banned from that position temporarily. I mean, he is removed from that position and till the time the trial is going on. So these laws are stringent. There are laws, but the implementation is not happening because of lack of knowledge, because lack of awareness. The people are thinks that it's a very expensive affair and also it's a time-consuming activity to go for the judiciary, and which actually is a reality. Actually, we advocate charge so much, and certainly the time period is also taking a lot of time. So these NGOs, what they are doing is they just want a simple complaint against any activity of this bribery and corruption. If they find it in their records, if this complaint is going,
the relationship among the three organs of the government in a written constitution, in a country where we have written constitution like India or Bangladesh or any other country or the United States, we have little difficulties about the separation of power between the three organs. But sometimes what happens, as just mentioned by the immediate past speaker, Phillips-Dr, the Member of Parliament, about some of the incidents about which I have very little knowledge to reply, but as a student of law, as I understand, is that if someone is aggrieved about any matter, he is free to seek his relief before the competent court of law. And for a judge, it is difficult to please both the parties. When an aggrieved person appears before the court, according to his own understanding and belief, he seeks relief. If he is successful, then definitely he is happy. But in every case, there is a possibility, of course, that one of the parties must be aggrieved even at the end of the day, because the verdict of the case must go in favor of one of the party. For this reason, we have hierarchy of cases, courts in different jurisdictions all over the world. Now the question is that if someone loses the case before the apex court of the country, what will happen? The answer is that that is the end of it, and the matter is final, and you have to accept it as a good place. Now coming to the topic of this working session about judiciary, legislature and executive. We have little difficulty in a written constitution. Even then, in a country like Bangladesh, we have experienced many extra constitutional phenomena in the past, and we have seen that the written constitution was amended on few occasions by extra constitutional phenomena. When the democracy was restored, the parliament came into session. To fill up the blank, as a working solution, some sort of legislation was enacted, what is called the Constitutional Fifth Amendment or 13th Amendment or 7th Amendment. These are nothing but mostly the 7th and the 5th to validate whatever legislation or enacted during the time of the military rulers. These were given legal coverage and some sort of immunity was given to the persons who were responsible for extra constitutional activities. But after the